Good afternoon, ladies and gentlemen. Welcome back. Our next panel is one that our team has been very excited about. You heard Ms. Crass's remarks yesterday that as national security legal practitioners, we have to carefully consider, and I quote, how to harmonize two interests, the right of the state to prevent foreign influence on government functions and the right of the individual to receive speech. For example, there may be some tension between Americans' right to receive speech and the nation's interest in preventing foreign influence on U.S. elections. As legal practitioners charged with both defending the nation and upholding the Constitution, we must navigate these issues, end quote. It is therefore nice to see that the U.S. isn't alone in navigating these complex legal areas. So perhaps we can learn something from our international partners on how they wrestle with this very issue. I'd like to introduce the moderator of our next panel, Lieutenant Commander Mike McCarthy. Mike is the Deputy Director, Directorate of Cyber Operations Law, Office of the Judge Advocate General for the Canadian Armed Forces. Mike has a brilliant legal mind, a great sense of humor, and is someone I'm lucky enough to call a friend. So, Mike, over to you.
Thank you very much, Sarah. Those were lovely lies you told about me. I do not. So, in the interest of everyone, the key to happiness is the management of expectations. So let me manage yours from the start. A brilliant legal mind I am not. However, I am very honored to be here with a collection of brilliant legal minds on a very interesting topic that affects all of us. So before we carry on, I would like each of the panel members to briefly, we've discussed briefness and brevity, to briefly introduce yourselves, and then we'll carry on. Sir?
Kia ora katoa. Wing Commander Tim Wood. I'm the Director of Operations and International Law in the New Zealand Defence Force. Brief enough?
Absolutely. Well done, sir.
Good afternoon, everyone. Thank you, Mike, and thank you for the invitation of the US Cyber Command. I'm Thomas Graindorge. I'm the Chief Legal Advisor of the French Cyber Defense Command.
Thank you, everyone, for having me. I'm Andrew Parker. I'm with the Communications Security Establishment. I'm a Department of Justice lawyer.
Good afternoon, everyone. I'm very happy to come here, and I'm Lieutenant Colonel Jinnai from Japan. So my position is legal advisor in the Central Support Unit of Japanese Japanese Ground Self-Defense Force. Thank you.
My name is Capt. Thadeous Larkin. I'm one of the legal advisors here at US Cyber Command. If you want to know my background, you can find me on LinkedIn.
There you go. Thank you so much, folks. All of us live in societies that value freedom of expression. As a Canadian, I look to the Canadian Charter of Rights and Freedoms, part of our Constitution, particularly Section 2, the Fundamental Freedoms section. And note that Section 2B included freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now, because we are being hosted here today by our lovely American colleagues, you know, it's nice to harken back to his January 6, 1941 speech. U.S. President Roosevelt spoke of the 4 essential human freedoms, including freedom of speech. There's also another, in deference to my French colleague, which it's a great quote in English, misattributed to Voltaire, which is, I disapprove of what you say, but I will defend to the death your right to say it, which remains one of the great summations of what freedom of speech entails. To speak and put it in a bit of an international law context, some examples from international law that recognize the importance of freedom of opinion and expression may be found in the Universal Declaration of Human Rights, Article 19, and the Preamble, the International Covenant on Civil and Political Rights, or ICCPR, Article 19, International Covenant on Economic, Social, and Cultural Rights, as well as the International Convention on the Elimination of Discrimination of All Forms of Racial Discrimination, Article 5, Convention on the Elimination of All Forms of Discrimination Against Women, Article 7. So one of the rights generally included, as has been discussed a couple of times this week, in the freedom of expression is the right, as described in the Universal Declaration of Human Rights, Article 19, to seek, receive, and impart information and ideas through any media, regardless of frontiers. Now, that means that it's not merely a right for the speaker, but also for the listener. All that being said, it's clear the freedom of expression is not unlimited, which is an important point to note. And if we're going to talk about how we deal with disinformation, I think that's a key piece to start with. Now, that's even recognized back to our international law piece In Article 4 of the International Convention on the Elimination of All Forms of Racial Discrimination, which calls on state parties to prohibit and make illegal the dissemination of certain ideas inciting racial discrimination. So, that's enough for me. Actually, that's way more than enough for me. Let's turn it over to my distinguished panelists. And I'd like to start with, we're going to do it with a bit of a series of questions. So the first one is, how does each country protect freedom of expression domestically and any international regional obligations you may have? So we'll start to my right, sir, if you don't mind.
Yeah, thanks, Mike. So New Zealand is very similar to Canada in that regard, insofar as we recognise the customary international law status of the Universal Declaration, and as you say, with regards to the norms set out in Article 19. Equally, New Zealand has ratified the ICCPR, again, with regards to Article 19. But we also recognise that there's a balance to be struck in that regard, and so acknowledge Article 19.3 of the ICCPR with regards to the three-pronged test of legality, necessity, and legitimacy. At the domestic level, it comes down to the New Zealand Bill of Rights Act, and in that regard, freedom of expression is codified under Section 14 of the bill, and forgive me if I read it because it's useful for us to appreciate the national standing. And there it kind of echoes the Universal Declaration to a certain extent and the ICCPR by saying everyone has the right to freedom of expression, including the right to seek, receive, and impart information and opinion of any kind in any form. However, as you say, those rights are not absolute and they can be restricted even in accordance with the New Zealand Bill of Rights, but only where there are reasonable limits prescribed by law as demonstrably justified in a free and democratic society. And that is key to a lot of what goes on with regards to expression and information being imparted and received back and forth. So that's the sort of structure upon which we focus our rights and the limitations that will be put in place. And I'll probably leave it there at this stage.
Excellent, thank you. Monsieur Thomas.
Thank you. In addition to international law, in France, we can find freedom of speech in our constitution, of course, the Treaty of the European Union, and also the European Convention for Human Rights. I would like to quote the Article 4 of our Bill of Rights, la Déclaration des droits de l'homme et du citoyen, which says, la liberté consiste à pouvoir faire tout ce qui ne nuit pas autrui. I say some word in French to make a little bit of exotism in that conference. But I will translate. Freedom consists in being able to do everything that does not harm others, so a little bit like your constitutions. We have to balance our freedom of speech with other rights, including population safety, too. It's quite the same position in the European Union and under the European Court, of course. Not always with the same balance, but the same position at least. This is why we can fight against terrorism and propaganda, which can be blocked and or deleted. The most important question maybe for me is, when do we stop being in freedom of speech? We don't have a clear position on that in France, but I may say that an unauthentic, coordinated behavior, especially made by foreign states, is not freedom of speech. If it's not a real person saying his own opinion, it can be freedom of speech. It's an information operation, so we will be, French government, open to act against it and use our administrative power of our French police.
Excellent. Andrew.
Well, like you said, Mike, in Canada we have the Canadian Charter of Rights and Freedoms, and Section 2B recognizes the rights to thought, belief, opinion, expression, including freedom of the press and media of communication. And expression itself has been defined as activities or communications that convey or attempt to convey meaning. And this has led to the courts interpreting this very broadly. So any type of expression, essentially, no matter how offensive, unpopular, disturbing, will be afforded some level of expression protection under the Canadian Charter. However, again, much like my colleagues, this is not absolute. Certain types of information have been deemed not to be expression, or convey meaning, rather. For example, a list of stolen credit cards that's being sold on the dark web, or personal information is an act of ransomware. In some cases, these have been deemed not to be conveying expression and therefore would not attract Section 2B protections. The other main exception in Canadian law is violence and threats of violence. While these may be expressive, the courts have deemed that they do not warrant a Section 2B charter protection. And then again, much like my colleagues in New Zealand, the Canadian Charter has a balancing section, Section 1 of the Charter, which provides for reasonable limitations on different freedoms and rights, provided that they're prescribed by law and reasonable in a democratic society. So that's sort of the legal framework that we go through when we're trying to determine whether or not we can infringe on freedom of expression.
Thank you very much, Andrew.
Okay, so with respect to the international relationships, so Japan is a signatory to the International Convention on Basic Human Rights, as Mike said before, and that's why Japan has a responsibility to comply with the authorities' obligation. But other than that, there is no specific regional or international obligation Japan has. And in terms of Japanese domestic law, Japanese constitution provides that the freedom of expression is one of the most important basic human rights. And Article 21 of the Japanese Constitution, the article says that any forms of expression shall be guaranteed. And not only that, but also it's a unique point of the Japanese Constitution that so the censorships and violation of secrecy of communication so also prohibited. That's why the government has very limited authority to regulate the freedom of expression. So that's a Japanese unique point. And only when the expression violates criminal law, government or the Japanese police can crack down on their expression. That's a very rare case.
Thank you very much. Thaddeus?
So first of all, as sort of a preliminary matter, I'm not speaking on behalf of Department of the Army, Department of Defense, United States Cyber Command. I'm here in personal capacity with my views. Secondly, when General Nakasone opened the day, one of the things that stuck out to me was he said what an important lesson that Cybercom learned was it's as much as giving as receiving, and so I'm very thankful for our partners. I'm just as pleased as can be that we're here with our partners having a dialogue about the freedom to have this dialogue, which is amazing. It's incredible, and I'm so happy and thankful. As to the United States and where we guarantee our freedom of expression, we come from a little bit different tradition for how we've developed our law. Obviously generated out of the American Revolution, where you had anti-monarchists who were afraid of a powerful federal government. So the anti-federalists insisted if they were going to pass the Constitution, they needed guarantees against an overarching or overreaching federal government power. So Bill of Rights, we insist on these 10 things that the government absolutely cannot do. One of the rights that are guaranteed to U.S. citizens, U.S. persons, is the right of expression, essentially, the freedom of speech. As Ms. Crass mentioned yesterday, that's not limited just to speaking, but it's also extended to your right to receive speech. Now, just like English grammar, there are rules, and then there are 4 billion exceptions that make it not even coherent. And the right to receive is just not that simple, right? So the real question is in the contours of where that right to either speak or receive speech comes in. That's a real interesting question. She mentioned Kleindienst v. Mandel. And that's where the Supreme Court of the United States reaffirmed you as U.S. persons have a right to receive foreign speech uninhibited. However, important to note, the United States prevailed in that case. Kleindienst won. Mandel was a Belgian socialist calling for uniting the communists of the world to overthrow their governments, and he was kept out of the United States as part of a plenary power. So that shows you that at the very least, the federal government, through certain avenues, can restrict, in certain circumstances, usually touching on national security or plenary powers, some aspects of your right to receive or speak.
Great, thank you very much. So my next question is going to be what criteria or considerations are used to assess information as misinformation or disinformation. Now, before we start with the questions, just, let's go back to pre-cyber days. This isn't new, right? As states are in that, phase of competition with each other, think back to the Cold War. Anybody familiar with Radio Europe, Radio Liberty? Because I'm pretty sure the Soviet bloc wasn't a big fan of, our collective efforts to broadcast into a closed society of the Soviet Union. So that's the other piece to bear in mind. We're talking about how we deal with disinformation and misinformation. And just like beauty, it's often in the eye of the beholder. And as lawyers, as legal advisors, it is incumbent upon us that we can't just sit back and say, but we're the good guys, so it's okay if we do it, and they're the bad guys. So we really have to put that legal rigor to any of the advice that we give, because it's very easy, and I'm sure in advising various operators and decision makers, we've at times had the experience where you fall into the trap, but Jag, come on, it's the right thing to do. To which, as a legal advisor, you always have to say, and what in the world are you basing that assessment of it's the right thing to do on? So I'll turn it back over to my distinguished panel to say, again, what criteria or considerations do you use to assess the information, whether it's disinformation or misinformation? We'll start with Tim.
Okay. We've heard various explanations or definitions of disinformation during the course of this conference. I thought it was really interesting yesterday that reference was made to covert activity was one of the criteria for disinformation, and that's certainly a distinct view from the way that the NZDF would describe or at least define disinformation. In the lexicon of the NZDF, we talk about disinformation being false or inaccurate information deliberately spread to deceive an audience or otherwise cause harm, i.e. to intentionally create conspiracy theories or rumors. So there's obviously some very clear parallels with other descriptions that we've heard. That's distinct from malinformation, which is, as far as the Defence Force sees it, is spread unintentionally or out of ignorance, and also distinct from malinformation, which is that deliberate publication of private information for personal or corporate gain. So we collectively refer to these terms as information disorder, and it's these various terms that has that potential to polarize public opinion, promote violent extremism, which is more relevant from the New Zealand context, and then particularly hate speech, which again was sort of excluded from the description yesterday, and also to undermine democracies and authorities. And I'm going to make a sort of, this is not a New Zealand accent, in case any of you are wondering. I'm British by birth. I've only been in New Zealand for 8 or 9 years, but I'm very much inculcated into the New Zealand culture. And we have a very strong sense of social cohesion in New Zealand. Civil society is very important. And so there are increasing concerns about the preponderance and proliferation of disinformation within New Zealand society. We have an organisation called the Disinformation Project, entirely independent from the Defence Force and government, and they highlight that there are differences and divisions that are being used to target and scapegoat, to normalise prejudices, and to harden those us and them mentalities and justify violence, which is increasingly being seen within New Zealand society. I mean, no disrespect when I say within the US you may be seeing some of that already. But that's something that's relatively novel within New Zealand, and is something that has really come to the fore since the COVID pandemic, where the lockdown allowed a lot of keyboard warriors to really start to vent their spleen as to the government's view on this or the government's view on that. And that is a real concern with regards to the hate speech in particular, and with a view to trying to create social division. And we're seeing far-right and conservative views within New Zealand, and opinions that are against anything you can possibly imagine, whether it's gun control, whether it's gay rights, whether it's transgender rights, whether it's Maori rights, which is very important in a bicultural society such as ours. And so the criteria for us with regards to disinformation, Mike, because I know you want me to move on, is the intention, the mens rea, as to whether you are intending to cause the problem and the conspiracy theory that you may be perpetuating through that disinformation.
Excellent. Thank you very much. And sorry, it's called the New Zealand Disinformation Center, or
sorry, the Disinformation Project.
Project.
Yeah.
Thank you.
Definitely worth visiting their website.
Yeah, that's one that's definitely
a lot of trend analysis that they do are really useful.
Great. Tomas?
There is no clear definition yet in France on online disinformation, misinformation. We are actually more focused, as I said, on foreign state operations, but also more focused on what is the objective of this misinformation, disinformation. If it has military implication, if it has impact on our military operation, of course the Ministry of Defense, the French Ministry of Defense will be very interested and can act in some case. But also if it has political or economical objective, it will be interesting for other agencies. I will talk about later. To be complete, we have a law since 2018 on misinformation, but again, it's focused on what purpose. It's only for misinformation with the aim to alter the sincerity of the ballot. So, and also, it does not apply to the user who publish misinformation, but only to the platform, only big platform, YouTube, Meta, Twitter, TikTok, and so on. They have an obligation of transparency. When you make marketing on political matter, you have to be clear to who is behind. Is it a political party? Is it a private company? Is it a foreign country? You have to be clear on that. And also, we have the possibility to ask easily to remove the content, but only during the election, so 3 months before and to the election.
Excellent.
I would agree. Canada is still trying to unpack what these various types of information are. But the one thing that I can point to is the Canadian Centre for Cybersecurity, which is a subsidiary within the Communication Security Establishment, has published some guidance on identifying misinformation, disinformation, and malinformation. And under that guidance, they identify misinformation as false information that's not intended to cause harm, disinformation as false information that is intended to cause damage, manipulate, or guide people, organizations, or countries in the wrong direction. And then malinformation is information that stems from the truth, but is exaggerated in a way that misleads or causes a potential harm. So in Canada, for the purposes of a charter analysis, a freedom of expression analysis, all of these would garner some form of freedom of expression protection.
So to be honest, it is very difficult for me to answer this question because Japan doesn't have any governmental organization to check this information. And so there's no legal restriction about this information. That's why also there is no official definition of misinformation or disinformation. And so in Japanese case, each ministry of agency check this information, and when they find this information, they try to correct respectively. That's why it is very difficult to say clearly what their standard or criteria in Japanese legal system. But instead of that, there is a private organization to conduct a fact check, and so the private organization is completely independent from government. And usually they check the information by confirming whether the information has concrete basis or not. I think it's a key point in deciding that it's disinformation or not. That's all.
Thank you. Thadeous?
You know, what is truth, said jesting pilot, but would not stay for an answer, right? Part of the issue that we have within the United States and with Department of Defense generally, we love definitions. We have a DoD dictionary that helps the uninitiated guide their way through when you're doing briefing bingo and you hear all these acronyms or what these specific terms mean so that everyone can orient themselves and get on the same level bubbles. That's not in there, but that probably should be. The problem in part is definitional at its core. Misinformation is defined, at least in part, in our information operations. That's where we lump it into. DoD Directive 3600.01 Info Ops and JP3 TAC 13. that's where we start to talk about information operations generally, and that's our guidance on, our joint guidance on the actual carrying out of information operations. And we start to talk about misinformation as unintentionally false information. Disinformation is untrue information spread intentionally. So one common thread that I've heard throughout is that this mens rea issue. That's really what it is. We're all lawyers here. So intent is a secret operation of the mind. So you have to sort of draw out from the facts whether or not this thing is or is not mis or disinformation. We also have a definition for propaganda. So GAO has a tripartite test for what constitutes propaganda from the US government. Why do they do that? Because the United States, fearful of an overreaching federal government or the establishment of a ministry of truth or the suppression of your First Amendment rights, is hesitant to spend US tax dollars on doing just that, or having US persons subject to propaganda by the United States. It's actually in our fiscal year NDAA 2019, what we've all been extolling up here and saying this gives such great authorities to US Cybercom, 1642 Alpha, 1642 Bravo. If you look at the committee notes, they also note, which this is a sort of, if a thrill of joy doesn't shoot through your leg when you're reading committee notes from NDAAs, then you're in the wrong business. But on those notes, what they mention is that authorization for military operations doesn't subsume the importance of not funding propaganda or not using cyber as a means, an enabler, to fund propaganda. So that's another part where we're hesitant. And the problem remains definitional. If you tell me where DoD says what misinformation or disinformation is, it's somewhere out there in the penumbras of our information operations.
Excellent. So, it's throughout this entire conference, I think a common theme for all of us has been, it's rather comforting to know that we all wrestle with the same issues. And you're not sitting there going, is it just us? So, misery loves company. Not going to say this is misery. It's actually fascinating work, and it keeps us all employed. So that is really important as well. So we briefly touched on it already, but if you don't mind, distinguished and honored panelists, I'll get each of you just to touch on a little bit what domestic authorities would be relied upon if you're going to take action to counter disinformation or misinformation. So again,
yeah.
Jim.
So as I've already alluded to, the situation in New Zealand is more domestically orientated. So we have discontented individuals, fringe media outlets, particular groups with particular opinions that may not necessarily accord with the mainstream perspective. So that's more of the focus rather than any suggestion of foreign influence, adverse influence that we've heard a lot about during the course of this conflict. And that's very much the assessment of the National Assessments Bureau, which is a bureau within the New Zealand Police. So we're focusing on a domestic element issue. And so because it's domestic, the way that one tends to deal with disinformation, it will be monitored, it will be reviewed and assessed by the police, by GCSB, the SIS, if it's overseas, but fundamentally it's the police role. And then, as I say, you have independent organizations who are doing trend analysis to identify these things, to draw them out. But it's a very difficult situation. And if I can use one example, is you may have picked up in the news recently that there was a visitor from the UK who came to Australia, caused a bit of a stir, and then was traveling on to New Zealand, was intending to travel on to New Zealand in order to speak with regards to the transgender issue. I forget the name of the lady, but she's known as Posy Parker. So that's probably something that's more resonant for you in terms of the media. Because of the issues that had arisen in Melbourne, in particular, where there was quite the scuffle and some far-right demonstrations, which I think, to be fair to her, were not part of her setup, but they took the opportunity to piggyback onto the words that she was saying. There was concern that if she came to New Zealand, that what she was speaking about could be categorized as hate speech. And we have legislation with regards to hate speech, particularly when it's for a racial element of it. So the transgender element kind of is difficult to see whether it sits within the elements of the offence within the legislation itself. But why it became such an interesting issue was that it became an immigration issue rather than a freedom of expression or imparting information to the public. So there was no suggestion that she would necessarily be prevented from coming into New Zealand because of what she might say, because the court said you may not necessarily agree with it and it may be distasteful, but it is not assessed that it is hate speech or would incite violence in itself. And so there's no reason to deny that individual a visa to come into New Zealand. And as a UK citizen, actually coming into New Zealand was relatively straightforward. Now, there was an interim injunctive application which was denied by the courts, and so you can see this balancing element between freedom of expression and imparting information. As it transpired, the first time she tried to step out and have a speech, there was a counter-protest and it got very violent, and so to a certain extent it worked to her favour because it drew more attention. But to get right back to answering the question in itself, Mike, for us, because it's more of a domestic situation, it's about domestic legislation. Mm-hmm. So whether it's to do with the chief censor who might be trying to deal with issues, and forgive me if I'm taking up too much time, but if you recall, and how do we figure out these things, but the Christchurch massacre of 2019 was live streamed as it was taking place. There was no actual legal ability to stop it at the time because the legislation did not allow the sort of dynamic agility that the General talked about this morning. And so we have gaps in our legislation, but it's domestic legislation that we have to rely upon in order to stop information which is deemed to have crossed that threshold. Thanks.
Fascinating.
We have three main entities in France. First, the French Cyber Defense Command. We are responsible for defensive and offensive cyber operations, but also online counter-influence operation. Our scope is, however, limited to the protection or the support of our operation, our military operations. No French territory, of course. On French territory, we have Viginum, digital vigilance, under the authority of the Prime Minister, whose missions are to detect and analyze foreign threats against France, in particular any electoral interference. The third is very interesting. It's a French police platform called Pharos, which sounds like a lighthouse in French, which can, without prior authorization from a judge, which can report any manifestly unlawful content to any platform, a big platform like YouTube, Twitter, and so on, but also any website which is accessible from the French territory. And of course, they can order them to remove the content under 48 hours, under 1 hour for terrorism content. Only for big platforms, this one. If necessary, and if the website doesn't comply, they can ask the service host or the internet service provider to make the content inaccessible from the French territory or sometimes the EU territory. So that's Pharos doesn't really fight against disinformation or misinformation, but it's very powerful and useful when you have when this is linked to an offense like call for violence, threat for violence, illicit traffic, or something like this. It has a very, very good result in France.
And just to be clear, you said they don't require judicial authorization before taking action.
Yes, of course. If there can be a control of the judge afterwards, right, of course, but they can act directly. That's why we call administrative police in France. Right. They can act directly.
Okay. So subject to judicial review, but does not require judicial authorization.
So it can be very fast and quick, and for terrorism content.
Absolutely.
Mm-hmm. If after 48 hours it's too late to remove, of course, so we have to be very quick.
Yeah, taking down some notes. That's very interesting.
Hints and tips, eh?
Yeah. For Canada, we also have domestic criminal legislation, hate speech laws, terrorism, speech laws, those types of things. But as counsel for the Communications Security Establishment, I'll talk specifically about the authorities that they use. CSE's mandate includes the collection of foreign intelligence, the protection of government in Canada networks and systems of importance, technical assistance to law enforcement, security agencies, the Canadian Forces, Department of Defense, and then foreign cyber operations, which are both defensive and active or offensive. CSE is a civilian standalone agency, but it is under the portfolio of the Minister of National Defense. And pursuant to the CSE Act, CSE can carry out defensive cyber operations on the global information infrastructure, or the internet, to protect federal institutions, information and information infrastructures, as well as those designated as being of importance to the Government of Canada. CSE can also carry out active cyber operations on the global information infrastructure that degrade, disrupt, influence, respond to, or interfere with the capabilities, intentions, and activities of a foreign state, individual, organization, or terrorist group as they relate to international affairs, defense, or security. So you can see there, this is the type of authority that Canada may look to in order to try to respond to some of these types of hostile information online.
Thank you.
Sure. As I mentioned earlier, so unfortunately, there is no organization to deal with disinformation in Japan, except for criminal cases. So criminal cases, Japanese police has a right to crack down on the disinformation. And additionally, when it comes to telecommunication, including internet, so the area is mainly under the control of Ministry of Internal Affairs and Communications. But the ministry is very negative to enact a law which would infringe on the disinformation. Because, as I mentioned earlier, the Japanese Constitution set very strict restrictions to the secrecy of communication and the freedom of expression. But last year, the Japanese government released new security policy last December. And in the strategy, finally, Japan recognized disinformation. Spreading disinformation is serious threat to the Japanese security. So, and the strategy said Japanese government will establish a new organization to deal with these problems. So, and not only that, Japanese self-defense force is also planning to establish a new unit to counter the information warfare, including disinformation.
Thank you very much. Eddie?
So, assuming we pass the threshold question of whether or not any action would violate the First Amendment of the Constitution. That's essentially where we're going to start our analysis, is if we assume that a U.S. person has a right to be intentionally misled by a foreign government acting covertly, whose express purpose is to undermine institutions and sow discord, if we pass that threshold and we don't make that assumption, then when it comes to Cyber Command, our authorities are going to stem from the executive branch. Article 2 of the U.S. Constitution, President of the United States as Commander-in-Chief of the Armed Forces. And shifting into how we've talked a lot about the NDAA, Congress just funds us. Congress doesn't have, besides declaring war, Congress isn't the legislative branch isn't the one who actually gets to direct the military, because that sort of collaboration isn't possible to make it efficient. So we house that in the executive. And in so doing, Congress gets to set our priorities through the budget. They've done that through the National Defense Authorization Act. 1642 Alpha and Bravo from fiscal year 2019 authorize active defense against the big four, so Russia, China, North Korea, Iran, including attempting to influence American elections and democratic political processes, and 1642 Bravo, private sector coordination for associated false online personas. We also have the fiscal year 22, 1508, which has to do more with cybersecurity. So there's some sort of a tertiary aspect to it there. And under fiscal year 19, NDAA 1632, yeah, traditional military activities. in which Congress affirms cyber military activities not in hostilities, including information operations, which is where those penumbras are for our disinformation. But that, again, it's a really high bar to set and look at to say, is this thing violative of the First Amendment? And I think Ms. Crass made that clear yesterday, that has to be where the analysis starts, not necessarily where it ends. But we have to clear that threshold before we could use a cyber-enabled activity to attempt to refute or combat it. The alternate is to put information out there in the public square. How does the U.S. respond, or its partners, or the private sector, how do they respond in a way that isn't necessarily the military, the US DoD or Cybercom doing something? Because when you're a hammer, everything looks like a nail. So if you can cooperate on those and put good information out there, flood the public square with counter information, then you would look to those information operations authorities.
Excellent. So back to that, the best way to deal with bad information is good information, and more good than bad. Easier said than done. Moving on to another question, though, would be, I think this is where we're going to get into some really interesting discussion, which is, what are the considerations in determining when to act and what action to take? And before we start, again, just keeping in mind, fundamentally, when we talk about this idea of limiting freedom of expression, freedom of speech, what are we afraid of? Is it the idea? Again, to riff off of Thadeous's piece, if you look at the creation of the United States, group of people had some very different ideas than the government of the day, and subsequently, your republic came to be. So are we afraid of the idea, or concerned about? Is it the effect of the idea? What particularly is that core fundamental issue? Because in our open societies that we all value and hold dear, that exchange of ideas and new ideas is very important. So it's just something to keep in mind as you think about that. So again, what are the considerations in determining when to act and what action to take?
Well, I know you're not necessarily looking for answers, but I think from a New Zealand perspective...
No, I really am looking for answers. I think all of us here would be really happy if you were like, here, do this. That'd be great.
So I think from a New Zealand perspective, it's the effect that we're particularly concerned about. And I think I've made reference to that with regards to some of the comments I've drawn on from various authors. We're concerned about what disinformation... First and foremost, everyone has the right to say what they want to say if those comments are based in respect and mutual appreciation for other people's ideas and thoughts and concerns. But ultimately, where you have information which is threatening social cohesion, where it runs the risk of inciting violence, racial violence, hatred, whatever it may well be, then there's going to be a need to control that in some way. And because our focus is very much domestic, the responses are very much domestic as well. So I made reference to injunctive applications or applications for injunctions in order to prevent people who are coming to the country, already in the country, from speaking. So, we don't need to make reference to people necessarily coming to New Zealand to speak, although there have been a number of visitors of late. But even if you've got someone within New Zealand who is planning on having a speech, and my colleague from the ministry will remember days of where there have been speeches which have been very divisive. Well, there will be special interest groups who will seek to get an injunction to prevent that speech ever taking place. And so that's one of the first options that's there. But then if that speech were to take place and it were considered to be offensive in a criminal sense, then there will be legislation which allows for investigation, as with any other offence that may have taken place in a domestic sphere. And those pieces of legislation are recognised as being in accordance with a demonstrably justifiable limit on the rights of every individual within New Zealand. So you have the New Zealand Law as the foundation, and then you have the legislation which builds on that, which restricts those rights. So that will be the way that things are definitely dealt with. But there needs to be a framework that is concrete, that is rational, and is not built on moral ambiguity. So this is the problem where we try to set thresholds and we try to strike balances, is where does that balance What does it rest upon when you actually put that bar across it? And from, certainly as a criminal prosecutor, as I have been for many years, is something that can be easily articulated is much easier than something which is slightly ethereal in that regard. So it's got to be measurable, particularly when we're trying to remove extremist or online or violent online material. But as I've demonstrated, we have gaps in our legislation. And so what often happens is the words are already spoken, and so the damage has been done. And then you're taking sort of criminal action after the effect. And is that necessarily the most effective way of dealing with these things? Perhaps not. And maybe the way forward from a New Zealand perspective is actually to try to rebuild the social cohesion so it doesn't actually occur in the first place. And that may be slightly naive and slightly sort of rainbow gazing type thing. But we have to find some way of actually trying to reduce the desire for people to speak in those ways.
Well, certainly a laudable goal. Would there be any difference to say how it would be approached if that same speech were to be, say, written somewhere else and broadcast from a third-party location into, or, you know, via cyber means, or even historically other means? How would it make much of a difference?
Yeah, I mean, there's legislation which is kind of the same legislation where they had problems with the Christchurch situation, and why you've got the Christchurch call working, obviously, New Zealand working very closely with France between our previous Prime Minister and President Macron in order to try to have better control. And again, it resonates with what has been described by the distinguished panelists about big tech dealing with the problem at the actual genesis of it, rather than the end user having to deal with it. And we're still in that end user situation. But if the Facebooks, the Twitters, God help us, and others were to deal with it when it's actually put on their platforms initially, because they actually had the staff and they had the devices and they had the analysis to be able to prevent it, then we'd be there. But from a domestic perspective, because you're then looking at whether material is objectionable or not, there are various processes that the censor has to go through, and that takes time. And by that stage, it's already viral, and it's too late. And this is with the issue with the Christchurch massacre, is that Facebook actually acted relatively quickly within 24 hours in the comparative terms, but by that stage there were millions and millions of copies of that film, which are still available on the dark web if you really want to find them. So there are, you know, it's a problem which is not unique to New Zealand.
I will only respond for the French Cyber Defense Command on that matter. We are doing military operations, so we will only react, if the disinformation impact or involve a military operation, as I said before. If it's disinformation on COVID, on vaccine, or something like that, of course, we can't act. It's not in our scope. Also, our purpose is not to limit personal opinion, to limit freedom of speech. That's not our work. It's a judge work. And Pharos, in some case, we are here to act against terrorist content and, as I said before too, unauthentic coordinated behavior. That's the only case when the French military will react. And of course, when or if we react, it's always in accordance with the international law, of course, peace or armed conflict, and our domestic laws too. It's where I get paid.
No shortage of work, and that's a wonderful thing. Andrew?
Well, as I mentioned earlier, the communication security establishment has the authority to carry out both defensive and offensive cyber operations. And the way they determine which specific operations to go about is on an annual basis. There are ministerial authorizations that are issued by the Minister of National Defense, consented to by the Minister of Foreign Affairs, and they set out the parameters of the different types of activities that would fall under this particular authority. So again, if we're conducting an operation in cyberspace that's going to potentially limit access by a Canadian or a person in Canada to information, or prevent a person in Canada or a Canadian from expressing themselves, then we're going to have to go through a charter analysis. And so the process to do that is built into this authorization that's issued by the Minister of National Defense. And in fact, there's a whole charter process in this authorization that asks a bunch of questions.
3 points. The first one is establishing a concrete basis. So, and the attribution is necessary, like cyber warfare. And the second point is the involvement of the private or third parties. So if the government itself decide to conduct operation, so it might lead to the arbitrary decision. So, and finally, I think it is very important to consider balance between the social interest in protecting freedom of expression and national security or interests. So without considering carefully, probably it leads to the damage to human rights. So that's a 3 point.
Excellent, thank you.
Yeah, so because the United States has the resources and the plan led by General Nakasone to defend forward, we're engaging on these questions all the time. Yep. And because we're such a big target, we are a target of misinformation, disinformation campaigns, and have been sort of perpetually going back since the founding. So our analysis will start usually with, whether we have the right capabilities, and then are we the right agency? And then we walk through our usual tests. Do we have the positive authority? Is there anything that restricts us? And then finally, is it lawful but awful? Is it, in terms of a policy question, what can we advise our commanders for what this does in precedence, or how this might impact their decision-making going forward? Because ultimately, that's all we do. We advise commanders. So they have a risk spectrum. And you heard General Nakasone up here earlier today talking about how we need to be agile. We need to be able to respond immediately. We don't have the room to be problem admirers who are just doing a lot of chin stroking, talking about the First Amendment. A commander is going to make a decision about whether or not a thing is going to occur in cyberspace. So we've got to ask commanders to weigh the effects of that thing, which, Andrew, I was particularly struck by how similar our analysis would track on the balancing of rights with the commander's constitutional oaths to uphold the Constitution. And Commander McCarthy, you talked about that at the beginning, the pressure to, we've got this cool thing and it's a bad guy, let's do it. Okay, well, you also raised your right hand and said, I will protect and defend the Constitution of the United States of America. So that's where our analysis will begin. What we don't want to do also is establish sort of an informational Praetorianism housed within the federal government. We don't want the Department of Defense being the gatekeeper of ideas and a ministry of truth that's preventing things from coming in. The Supreme Court of the United States, when weighing First Amendment issues, recently has struggled to justify its, it keeps repeating sort of the internet is the town square, it's the public square. But, and you alluded to this earlier, sir, it's not at all. It's a bad LSD trip that offers up examples of the worst of humanity allowed by anonymity online, like just the worst impulses of the human animal. As long as you're behind a screen and people can't figure out what you're doing, it's horrifying. And political opinions from my family, which is why I'm off of Facebook. I want to keep loving them. So what we want is a fair fight with our adversaries. If we're going to be putting information out into the public square, we want to know who it is that we're debating with. And we want to know whether or not those folks, because you can't change people's minds. We're not going to educate people away from holding or determining their own truths. So at the very least, what we want to do is to be able to uncover who is making these statements and what their intent might be. That, to me, is sort of where you can put the pressure. Because then Facebook and Twitter, they experimented with this. Hey, this is disinformation. This is misinformation. You know what it did? It made people dig in their heels even further and say, I trust and like this person because the big corporations are telling me not to. Same thing with the federal government. We don't want to put ourselves in that position as cyber.
Big run on tinfoil for the hats at that time, yeah.
Yeah, that trust deficit that we're not trying to get behind. So what I think everyone needs to do is to get outside more. Frankly, get away from your computers. That's really the answer. Stop reading message boards.
To all the people that are watching this online, not right now. Now is not the right time to go outside. It's weird and scary out there. Stay in here on the internet. It's fine. It's much more entertaining. We provided the content. But you're absolutely right, Thaddeus. Is like, who gets to be the grand arbiter of truth? I'm sure it would come with an awesome cape, maybe a funny hat, but you know, who gets to be the grand arbiter of truth in any particular jurisdiction? And it's like the reasonable person test for a judge, right? The reasonable person, if no one has, you know, enlightened you to this magical fact in law, in the practice of it at least, the reasonable person is the judge. Because the judge is going to sit there in judgment and say, well, I'm a reasonable person, this is what I think. So, however, as we see from all the various levels of courts and courts of appeal and all those things, and that great, you know, the great statement about whatever the final appeal court in any jurisdiction is, they're not right because they're final. You know, sorry, they're not final because they're right because they're final. And that's, you know, that's the truth. So you've got a variety of reasonable people along the way there. So trying to pick out your grand arbiter of truth would be very difficult. We're very quickly running out of time, but if we could indulge with a question or two from the audience, that would be wonderful. And I'll plant one for you, and that is that whole point of anonymity has been brought up, and this is more of a question I'm going to ask you to think about, not necessarily answer, but we talk about anonymity, and getting rid of anonymity is going to be the grand, wonderful protector of we're all going to suddenly be better. That's great. What if you're in one of those 4 states mentioned in the various, you know, U.S. defense authorizations of China, North Korea, Russia, or Iran? But the fact that anonymity is necessary for people to exercise freedom of expression without getting defenestrated or worse. So I'll throw that out to the audience for some consideration. And oh, perfect, man. Thank you. So we've got, I'll start right there, and again, Marguerite.
Sure.
So pick your panelists to start. It'll speed things up.
So I'm Captain Shane Bagwell. I'm the Chief of Military Justice at Fort Meade. And I was always listening to the way everyone was discussing these issues. I noticed that the way you addressed, or the way you approached it was very different. So I was thinking New Zealand had a very, you kept bringing up social cohesion and consciousness. Japan, I know there's a concept of, forgive me if I'm pronouncing it wrong, wa, like the harmonious approach towards society. And the American approach is very lowercase c conservative of protect the process and the law. And I'm kind of curious, in addressing this as such a global issue, how much do you think those cultural considerations make it difficult to have a cohesive international legal approach to interpreting some of these limitations and freedoms?
Who would like to volunteer to answer that? No?
So I think the Japanese situation is unique because, difficult to say, but so Japan has a history that before World War II, the military controlled all expression. That's why Japanese people are very sensitive that the government try to control the expression. So that's why. So even though Japanese government recognize the serious threat of disinformation, but not be can be aggressive to organize their posture. So it probably influence on the how can I say behind all the Japanese how can I say effort to dealing with disinformation.
Thank you. Marguerite?
Boy, I have so many questions. I think I would like
Limit yourself to one.
Yeah, sorry. I use freedom of expression as one of my areas of interest. But I would just note a couple things. I thought it was really interesting what the New Zealand participant was saying about excluding aliens from territory as being separate from excluding the speech. I think that was also what was going on in the Kleindienst speech or case that was mentioned. And so I guess I would just caution that I don't know if those two things map entirely one on the other. If I recall right, the U.S. Supreme Court kind of declined to do that balancing with the First Amendment, kind of said, we won't look at that, we're just going to look at the right to exclude. So I think there's still a question there to be explored for cyberspace purposes. I also think that, Thaddeus, you said something really interesting when, and maybe you were being a little bit flippant, but I think you put your finger on something really that I've been wondering about when you said, assuming there's a right to be deceived by a foreign government, et cetera, et cetera. And that is exactly kind of my question when it comes to disinformation. Yes, there's a right to receive information. There's a right to receive foreign propaganda, according to Postmaster General. But does it have to be knowing in order for that person to be exercising that right? If the person is being deceived and they don't know the source, does that mean the right's not in play? And I don't know what the answer to that is, but I think it's an interesting question. And then finally, again, going to something that Thaddeus said, I'm trained in the US tradition as well, so lots of thoughts there. But I think you landed at the end in saying something like maybe the best response is to expose the source rather than to suppress the content. And that certainly goes back to longstanding US tradition of counterspeech, and including our Foreign Agents Registration Act, which I know is criticized and portrayed as something that is suppressing speech, but is really not meant to. It really is meant to inform the audience, and maybe that's one way we could approach it. And then finally, on the cultural considerations and coherent approach, I think that is a really important question as well, because social cohesion sounds like something maybe for some of us, but is going to sound like something entirely different, say in China, and be used for very different ends. So just something that we need to think about when we're trying to articulate the balance for what we do in this space as well.
Yeah, that I think is where the analysis is interesting in the contours. It's within that covertness question that is really the sort of where we're going to hang our hat. And finally, as to the registration or exposing those people, more difficult when you are using exquisite cyber means to find out who it is in the first place, because then you've got to show your work. And then all of a sudden you've lost access to this thing and probably lost the mouse in the wall somewhere.
Another point would be, you talk about, and your points are excellent, Marguerite, you talk about, foreign government. What about a foreign government masquerade, through the botnet piece, right? So Mary from Idaho is actually not. She's one of, however many thousand botnet created by pick someone somewhere that's not Mary from Idaho, and maybe from one of those 4 stated countries that Cyber Command needs to be very, very concerned about. Does that right even exist then if you've got that many cutouts and pieces? And it's a very curious thing, I think, for all. And again, are you looking at it the international piece, where any form, any means, anywhere, regardless of frontiers, and then that interplay with the domestic concerns? And I do believe that is us for time, and my apologies for going 5 minutes over. If you have or would like to engage more with the distinguished panelists, notice, not me, well, please, by all means get in touch, but I think all of us would be more than happy to hear from people on this topic. Thank you so much, and thank you very much.
Thank you to Mike, and thank you, gentlemen. That was wonderful. For the live audience, we are on break until 14:50, so please be back in your seats, 14:50. Thank you.
Did we scratch your itch, sir?
Thank you.
So wonderful.
Thank you.
Well, thank you, Sarah. Thank you. I appreciate it.
Like, here's a week of a conference on this.
Thank you.
Yeah, well, happy to. Yeah, yep.
Hey, Sarah. Appreciate it.
We have another hour,
Yeah.
maybe. Sit back.
No cons going.
Thank you. Thank you very much.
Thank you.
Just because I didn't give anyone a chance to.